Good afternoon. Today we're going to be training on depositions. With us today is Eric Adams, and you're in for a real treat. Eric's been working with us for some time, especially working with us on some Dalbert motions. And Eric is one of the smartest people I've ever met. And so Eric is a partner with Shutts Bowen in the Tampa office. He's he's been recognized as one of the best lawyers in America for quite some time, and he concentrates his practice in estate litigation. He prosecutes, he defends. He his litigation involves estates, trust, probate, guardianship, commercial litigation. Eric has a lot of litigation experience, has done a lot of depositions, and you are really going to enjoy today's presentation. It will be interactive. We won't be doing the breakout rooms, but it's going to be very interactive, and I'm really excited for it. We are setting ourselves up for success. Eric will be back with us for the in-person sessions in Orlando. And so this is setting the stage for that training, and I think you're going to get a lot out of it. So with that, I'm going to pass it to Eric.
Thank you, Alicia. My name's Eric Adams, and I'm the guy that is going to not be putting you to sleep today. My goal more than anything else is going to be to walk you through and have some interactive exercises where you can come through and feel like you've got some new tools in your tool chest. This is our title slide, and it's kind of also our agenda. Our first subject matter is going to be some information gathering techniques. I'm going to teach you about the funnel method and the piece method. Zoom. The second category we're going to deal with is handling objections, both making them yourself and dealing with inappropriate objections by your opposing counsel. We're going to talk about ethical witness preparation, things you can or can't do, things your opposing counsel should and should not do when they're preparing a witness. And then we're also going to talk about navigating post-pandemic hurdles. We have a couple of things I want to explain that we're going to do to keep things participatory today. It's really tough when you have a group of more than 100 people, divvying people up into breakout rooms and creating exercises without us spending half our time divvying up into breakout rooms. And so we're going to use a couple of different tools. We're going to use the Zoom chat for you guys to share via chat what's going on and some feedback at the appropriate times. The other thing that we're going to do is we're going to use what's called a Zoom collaborative whiteboard. At one point in time, and I'll prompt you about this, we're going to put a whiteboard up, and you guys are going to get an opportunity to share, and I'll walk you through that particular exercise. And we're also going to have some quizzes. We've got some hypothetical questions with 4 different quizzes, and we're going to walk you through those quizzes where you guys get to talk about and answer some of those hypothetical questions. Just a heads up, don't go adjusting your computer. A couple of the videos that we're going to show you during the section on Zoom fails actually demonstrate, technological problems with remote technology, and they're emulating the problems that you guys experience. So don't go adjusting your TV set when you see a couple of the videos. I'll give you another warning again, but I just wanted to let you know that it's intended to kind of simulate in a humorous fashion some of the other videos or some of the problems you might experience. In addition to those humorous videos, we're going to see a video about a man in Texas who was an expert witness in a fight that nearly broke out at the deposition. We're going to see an excerpt of a sitcom called Superstore, where the manager of the Superstore did a very bad job getting prepared for and conducting his deposition. And then we're also going to do an exercise, I'm calling it our closing exercise at the very end, where Upright Citizens Brigade took the verbatim portion of a transcript from Cleveland, Ohio, and turned it into a short video. And it's a bunch of lawyers and witnesses having a knockdown, drag-out fight about the definition of a photocopier and what a photocopier is. You won't believe it. But the last video, the one on the photocopier, that's your final exam. And it's then during the chat when I'm going to, and I'll pause the video at the right times, but I'm going to be prompting you guys in the chat to give me some feedback about what folks are doing wrong, what they could do differently. And then at the end of it all, and I may take it and share it with Alicia or Paul or Candace, but at the end of it all, I'm going to take your chats and I'm going to turn them into a word drawing where we take all of your words and assemble them together so you guys can see the magnitude of your participation in what we're talking about here on depositions. And it's called a word cloud, where they assemble all the words from the chat. I'm going to collect them all together, and we're going to build a word cloud out of our collaborative exercise that we've done together. So that's kind of our goal. And here's what we're not going to do. We are not going to be having let me get back into my slideshow. We are not going to be dimming the lights so I can read the exact slide of the text or the text of the exact slide to you. I have a longer outline. My outline's in excess of 20 pages. I am more than happy to share it with your team leaders, and so you guys can have it. You don't need to be writing down case sites. I want you guys listening, soaking it in, and at the right times participating in the chat. And the slides themselves are meant to complement our conversation. And if you need some of the materials or some of the case citations, absolutely we can share the outline with you. But I kind of want you guys hanging out, participating, and kind of being sponges more than I do note takers. All right, so this is just a recap of what we talked about at the outset. What I'm going to do first, though, is I'm going to show you this Superstore clip. And the Superstore clip that I'm going to show you is a video of a manager after an accident. It's a sitcom, so it's fictional. But there was an accident where somebody got electrocuted by a robot inside of the store. And the personal injury lawyer has wanted to take the manager's deposition. And one of the employees who has a whole year of law school under his belt decides he's going to prepare the manager. And what I want you guys to do, and this next slide will give you your instructions. I want you guys, while you're watching this video, to do the following. I want you to look at the mistakes that were made by the witnesses that could have been cured through better preparation. And I want you guys to identify certain ethical boundaries that may have been crossed after the manager's deposition and before the other employees are being deposed. And there's no magical words to use in the chat, but I want you to memorialize this in the chat when you see things. There's going to be things inside of here that are going to resonate with you a little bit when we do some of our programming later on. For example, telling a witness what the answer to a question should be, as opposed to allowing a witness to truthfully testify. So I look forward to witnessing kind of your participation by chat every once in a while. And I may pause the video a few different times just to illustrate an example. So get your fingers on your keyboards and your listening ears on, and I'm getting ready to start our video. And it'll last about 3 or 4 minutes. It has a couple of different stages to it, and it's going to set the stage for some of the exercises we're going to do. So look forward to your thoughtful comments, and let's get the video started. I'm going to back it up just a few seconds, and then I will...
Oh, hey, Glenn, you're...
What is this? Are you doing it now?
These are the awkward silences.
Are you mad at me?
Did
you find out that I accidentally hit your car in the parking lot? Because it was just a scratch. You think you're so perfect? Well, I used to have a body like that once. So, so check out your future, you fart face.
Okay, so some things to work on.
On the day of the incident, Glenn Sturgis was floor supervisor.
Yes, he was.
To the best of your knowledge, did Mr. Sturgis make any modifications to the robot?
Oh, no, Glenn would never do anything like that. No, Glenn's a bit of a technophobe,
So let's pause here for just a second. This lawyer asked the smart witness preparer with 1 year of law school experience, did Glenn Sturgis, ever make any repairs to the robot? The answer to that question was no. He begins to then volunteer all sorts of information about Glenn being a technophobe and Glenn having problems with technology and not wanting to get near the robot. And watch what a skilled lawyer does with that volunteered information.
He keeps his radio dialed to the Christmas station all year round because he's worried he's not going to be able to find his way back.
So it's your understanding that he generally avoided the robot?
Oh, absolutely.
So that would include performing the required maintenance and software updates.
Sorry?
That's the responsibility of the floor supervisor.
Oh, I did not know that.
A skipped or improperly performed update could have resulted in the electrocution of my client. So.
Yeah, well, I mean, I'm sure Glenn tried to do the updates. This is not like to fill the silence.
And here he is not following his own advice, getting ready to fill a silence when there's no question pending and getting ready to fix the situation that he's created.
Or whatever, but just to say it, shouldn't there have been like a technician or something involved? I mean, I feel like it's unfair to expect somebody like Glenn.
Somebody like Glenn? Is there a competence issue?
No. Glenn can be competent in a lot of ways. Do you want to jump in here?
This lawsuit is against the Cloud9 Corporation, but it sounds like you're saying that Mr. Sturgis, as an individual, is responsible for the injury.
It's not your turn to ask questions.
Thank you.
But I like that question, so I'll ask it.
Objection. Overruled. Yeah. Hey, Glenn, you're
So I'm going to pause this for just a second. What the witness decides he's going to do then is he's going to go talk to all the employees who are then going to offer up examples of how competent this manager is. This employee took it upon himself to go out and do this exercise, and it goes horribly wrong. And he should have just listened to the questions that were being asked and answered the questions. And I'm going to take you to an example of what some of those other depositions look like.
like he's, good at his job, which he is.
And when the system went down, Glenn put in everybody's hours for the previous week from memory.
And why did the system go down?
Because somebody spilled juice on the clocking machine.
Was there a child in the back area?
No, it was an adult that was running away with juice because they weren't supposed to be drinking it.
And this adult was?
Bad at running with juice.
Would you say that Glenn Sturgis is a competent manager?
Is this off the record or?
This is all under oath.
It's under, great. Oh boy. Okay. Glenn is. What is Glenn? Glenn is, he is, it's the thing is about him.
Glenn and I, we're top dogs in this doghouse. Why? Competence. Jonah's the most competent. Then Dina, obviously. Preeti is probably up there too. Oh, Mateo. Jeez, okay.
Glenn can handle phone calls, yeah, keep things in binders. Oh, he wears clothes. Honestly, when you add it up, he can do like probably hundreds of things.
All right. So this is a great example of a sitcom giving us circumstances where a deposition goes horribly wrong. We're going to learn about a few of the things in witness prep that you can and can't do. This employee went into the break room and decided that he was going to be speaking to everybody and letting them know how they needed to testify and demonstrating Glenn's competence. And, it goes horribly wrong because these folks are just getting torn up by the lawyer on the other side. And one of the biggest problems they've got is perhaps encouraging people to say things that are less than true. You can watch these witnesses struggle with some of the information when they're asked about this, the competence of this particular manager. Some might even suggest that they were being encouraged to tell half-truths. And so what I want you guys to be able to do when you are preparing for the depositions is I want you to be able to be as surgical as the lawyer representing the injured employee when you are exhausting a witness's knowledge and taking them down to an area where it benefits and helps your case. And that's what we're going to talk about next. All right. So we're going to talk about information gathering techniques. And on the information gathering techniques, I am of the opinion that the most important thing that you can do in every case where you're taking your depositions is that absolutely knowing your case is essential. Knowing the parties, knowing the players, knowing the legal issues, knowing the documents that are at issue, the medical records that are at issue. I think the second most important thing besides understanding your case is understanding your witness. Your witnesses have motives. Their motives may be to protect themselves, from consequences or penalties. Their motives may be to protect the child and look out for the best interest of a child. Their motives may be self-interest and profiteering. Their motives may be to protect somebody else that's involved in a situation. But understanding your witness and their role in your case and what their motives may be is going to help you prepare for your information gathering deposition. You should plan for your deposition strategically. I recommend setting the stage and defining your goals for your deposition. And when I say that, here's what I mean is when you're setting the stage, I'm thinking at the outset of your deposition that you're fostering the communications to get the information you want. I am a big, big believer. I usually do this in most depositions. I have a Jekyll and Hyde attitude. I start out the first piece establishing a rapport, gathering factual information, and working on my baseline stuff. I usually take a break, and then I bust out with some documents and get some more information. And then at the end, depending upon the nature of the case and the witness, is when I'll ask some of the tougher questions. If I come out of the gate like a bull in the china shop, more often than not, the witness is going to be distanced and the witness is going to be protective of and cautious. I try to establish and earn a rapport. I try to establish a sense of reliable information with data that's confirmable, like through records if appropriate. And then at the end is when I'm going to come in, with some of the harder and tougher questions. When I talk about knowing your case, I'm talking about knowing where the facts are. I'm talking about knowing where the themes are, but I'm also talking about knowing where your gaps are. Because I don't always know a case, but sometimes knowing where my holes are is going to help me figure out what I need to do in the deposition. So don't just look for what you've got, but look for what you don't have. Look for the negative space that you've got, because that's where the witness may be able to fill in certain things and you can ask the witness about it. And when I talk to you about understanding your witness, the things I'm talking about are things like, what does this witness know? How is this witness biased? What's this witness's communication style? Are they a person with a PhD who's serving as an expert witness? Or are they somebody who's recently gotten out of jail and is being accused of harming or injuring another person? What's their style, and where do they end up coming from? And when I talk about strategic planning or planning your deposition strategically, what I'm talking about is just envisioning what the story arc looks like and where it fits into the big picture of your case. Because it's in developing themes like that when you're trying a case, your themes start to resonate a bit, and it helps you be a more effective storyteller and a more effective advocate. I like this PEACE model. PEAC is in a model for taking depositions, and the first is prepare. The second is engage. The third is account. The fourth is closure, And the E in peace is evaluation. In other words, half the work I do when I'm done with the deposition is digesting what it is that I got out of the deposition and how I'm going to use it elsewhere. It's not enough for you to get the transcript, put it in your file, and move on to the next one. I think your depositions of other witnesses will be much more effective. When you mine those depositions, you see how they fit into your case, and you evaluate their usefulness and any gaps that you need to fill. I also like the evaluation after the fact if it's my client that's being deposed, because I get to do the errata sheet, and you get to work on an errata sheet if it's appropriate or if it's necessary. And so when we're talking about this piece method, my other favorite analogy to give you is something that's referred to as the funnel method. And I'm going to stop my screen share for just a minute and share with you the funnel method so you don't get too bored with the PowerPoints. The funnel method is the idea of starting out broad and asking general information and bringing it down to points of specificity and narrowing it down. And when I think of the funnel method, I think of it a little bit like, you find out something general about somebody, and then you start asking them about, what their positions are that they've had. For example, if it's about their employment experience, you ask them about their positions, you ask them what they do in their positions, you ask them what the relevant position was at the time, and then you ask them about the day at issue and what they were doing. And you can see it just slowly starting to narrow down in that funnel exercise. And I open up new funnels for new issues, and then I exhaust them down to the narrower points. And so if you start broad, exhaust, and go down to narrow, it's a super, super powerful method where you can gather information from folks. It feels like a conversation, but you're really kind of juicing them like an orange is one way I think of it. There's a couple of different techniques that I like to use sometimes too when I'm asking questions. Sometimes it's appropriate to do what I call free recall. Like, tell me everything about the time that the child was in the hospital. Or tell me everything about the time when you guys traveled out of town to Nashville, Tennessee, and there was an incident. Sometimes I ask witnesses to do things in a reverse order. I like this exercise because that's how I find my wallet sometimes. Where was the last place I was? And I retrace my steps. And looking at something chronologically, if you ask witness to back it up from the time that they were at the emergency room to the time that the paramedics came to the time that there was a conflict at the house, if you go in a different direction, sometimes you can help with the recall of a witness. And so when you're doing your examination technique, don't be stuck to a chronological approach, because if you go the other direction, sometimes you can shake a few things loose. Go to the next one. So I talked a little bit about some of the questioning techniques I use, the open-ended piece. The leading one I like quite a bit, especially if you've got a hostile witness. If you've got a witness who was standing outside of a house at 11 p.m. at night and suggesting that they saw something, it's entirely appropriate to treat that witness in a way where you could say, it was dark, wasn't it? It was difficult to see, wasn't it? There wasn't much lighting, was there? Questions that are suggesting your answer. You do that with a witness that's hard to control, where the witness may be hostile, and where the witness's prior testimony suggests something to where you want to push with a leading question. We'll talk a little bit about objections and when the right time is to object to a leading question. But if the witness is an adversary or a hostile witness, leading questions are appropriate. I love a good single fact question. Sometimes you'll have a witness that is like Glenn Sturgis in the video and audio you guys heard or listened to. And Glenn Sturgis was the really ineffective manager. And he had a hard time, and some of the employees had a hard time in their depositions, staying nailed down to something. And sometimes I will just bust out with a single isolative fact that's pinpoint, because I need that particular fact. I don't want to leave it up to a narrative, and I need that pinpoint. That's a great technique when you've got a problematic, rambling witness. I love clarification and challenging questions. I love to clarify where I can test someone's estimate of something, either time or distance or severity or significance. I like to probe prior answers, and I like to challenge them a little bit. And then the last piece is it's about delivery and control. I think that giving a deposition is as much about the answers that you're getting from the witness as it is about how you conduct yourself in the course of that deposition. I like to vary my pace and my tone. I like to mix it up a little bit with witnesses. I think it helps you stay more engaged with the witness and the witness to stay more engaged with you. I also love to use my body language. If I'm maintaining eye contact or I'm projecting confidence with my tone or my voice. And I also like to, when a witness is telling me things I like to hear, I absolutely love to nod my head and give encouraging, I wouldn't say, Yes, yes, but just encouraging body language and body behavior, all those sorts of things. Let the witness know, especially in awkward Zoom environments. Sometimes let the witness know you're hearing them, and it kind of sends a message a little bit. And so those are some suggestions on the technique piece of the equation. I love to use exhibits. I tend to be, like I told you on my strategy piece, I tend to be curious and not use any paper for at least the first portion of the deposition. And then usually after the first break is when I either use exhibits to corroborate or to challenge the witness's testimony. I don't want to recover it, but I already talked a little bit about the funnel technique where you ask these broad open-ended questions and you get down to narrower stuff when you're moving to specifics. But I do want to talk a little bit about this idea of covering essential topics. I usually start out an outline for a deposition with a list of the things that I want to try to establish in that deposition. I have an outline of questions or categories where I'm going to be asking some people, the witnesses, questions, but I don't stick to my outline exclusively because sometimes having that outline will take me away from my follow-up questions. And so when I have that list of essential topics that I want to cover, it gives me my blanket that I can kind of comfort blanket that I can go back to and look at without being scripted to an outline to make sure that I covered, the essential topics that were necessary for this particular deposition. You would be shocked how many lawyers and litigators are conflict avoidant. I'll sometimes talk to some of my colleagues and I'll say, why didn't you ask the tough question? And some people are afraid of the answer to a tough question because they think it might damage their case. Some lawyers are conflict avoidant because a tough question could offend a witness or set the witness off, but maybe not if you establish that rapport. Sometimes people feel like tough questions might be unprofessional or it might elevate the emotional level at a deposition. But I'm telling you that I think persistence with tough questions is where cases are won and lost. Because two things happen. You might not like the answer, but it's better to know the answer than get ambushed by it at a final hearing. So I like the tough questions because sometimes the answers you get to the tough questions, it puts some meat on the bones and you look at it and suddenly the tough question doesn't look so tough. Every once in a while you get a little treasure and you get a little piece of it all. And I absolutely think that the idea of staying true to the tough questions is really, really important because your opposing counsel isn't going to stay away from those tough questions. And I think we need to, as we take depositions, normalize the idea of, for lack of a better word, an uncomfortable inquiry. And when I say an uncomfortable inquiry, it's going to be an awkward conversation. You're not going to necessarily like that conversation with the folks that you're talking to because they're going to act offended. There's going to be some confrontation, but you're going to get the answer to what likely is to be a pivotal question. So I'm going to go back. I've given you enough of a break from the PowerPoint that was likely going to put you to sleep, not unlike your Thanksgiving turkey. And so I'm going to go back and put it back on the screen for just a second. All right. So I think, and I mentioned this about my outline, outlines are great, but don't be so wedded to your outline that you don't stay flexible and you don't adapt. The best depositions that I've ever taken in my life, I feel like, are the ones where I was a great listener and I adapted on the fly because it gives you a chance, a meaningful chance, I think, to kind of run certain issues to ground. So don't be so married to your outline that you have it up in front of your face like this and you're reading it like a script. Yeah, have those essential points that are essential topics so that later on you can go back and make sure that you've covered them. And when you've got the topic covered, you think you've exhausted it through your funnel method, check it off and move on to the next topic and make sure you got what you need. All right, so on the information gathering techniques, we're going to move to another topic now. But the one thing I want you to take away is think about your theme. Your preparation is paramount. Think about your key exhibits and use some of the cognitive techniques, whether it's the piece method or the funnel method, in order to drill down and get the best information. And don't stay so married to your outline that you don't ask the follow-up questions. All right, so what's happening next is, I'm going to go to my next slide here. We're going to talk a little bit about handling objections. And if anybody remembers the old cartoon from the papers, when they used to have comics and papers, there was this one called Bloom County. And there was a famous penguin in Bloom County. I think his name was Opus. And it talks about here, a lawyer's talking, and Your Honor, the prosecution would like to submit the following, and he gets an objection, he gets interrupted. And the objections are absurd. I object to that motion. I object to your nose, your crummy TV, the arms race, any chronic hunger. But the funny part about this is this looks absurd and it's in a comic strip. But when I show you the real life video of the Texas lawyers and the professional witness, it almost makes this comic strip look like it's tame. And so I'm going to show you a good example. But before I show you that example, we're going to open up our whiteboard. And so here's how the whiteboard is going to end up working. Let me get to it. I'm going to stop our share. But let me talk about the instructions. I'm going to open up a collaborative whiteboard for everybody. And I want you, despite my typo, which I'm going to fix on the fly here, I want you to demonstrate the different types of objections you've heard. There can be objections to form, objections to all sorts of different stuff. So let me stop my sharing and pull up my collaborative whiteboard. And then you guys will have a chance, as we open up the whiteboard in this Zoom, to share with me your thoughts about the kind of objections you either use or the kind of objections you hear. You should see on your screens now a collaborative whiteboard with a toolbar along the left-hand side. I recommend clicking on the text window, creating this, and you can type in the kind of objections you might hear, like objection, asked, and answered. So let's take 2 or 3 minutes on this exercise for you guys to go through and add to our whiteboard here the sorts of objections you see. So I see somebody was starting to type the word hearsay. I'm going to let you guys play around with this functionality for a few minutes and put the sorts of objections you hear or that you use, and we'll collaborate on it a little bit. So have fun, use the text bar, and I will try to narrate it. Oh, I see one for relevance. We're going to be talking about that. Oh, I saw one for badgering, that you're beating up the witness or you're being hostile. Okay. The witness lacking knowledge, no foundation. Okay, those are all really good ones. I see lack of foundation. Hearsay. I love hearsay, but hearsay almost never has an objection placed at a deposition. But at a final hearing, absolutely. And we can talk, we won't be covering hearsay today. I see some of you are having a hard time with the whiteboard. And if you are having a hard time with the whiteboard, feel free to use the chat. No worries. Confusing the witness, vague or ambiguous. I love it. Those are all great. Sometimes it can be really simple, like objection to form, and just stop. I also, exceeding the scope of the prior direct compound question. I like this one. The counsel is testifying. I see that every once in a while. I see some other folks assuming facts not in evidence, argumentative. If it's a hostile witness and someone says you're being argumentative to the witness, my answer is no. I'm just asking a witness that has an adverse legal position tough questions, and I'll proceed. Calls for a narrative. That's another very good one. Gotcha. Okay, cool. We're starting to see sometimes what I'm starting to see some repetition. So I'm going to take the whiteboard down because you guys are great. I loved what you guys added to the table. And what I want to share with you as we go through our substantive exercises, I'm going to go back to my PowerPoint presentation, and I'm going to share with you a few ideas about handling objections and how they work. All right, cool. So let's do this. Let's first show you the video, and I'm going to stop my share and reshare it just to make sure that the audio is going to end up coming through. I'm going to show you a video of a deposition gone wrong in Texas. And there are all sorts of objections, some of which they were made up completely and didn't appear on our whiteboard, and some of which ended up with an invitation to fisticuffs out in the parking lot after the deposition. So if you can hear it, great. If you can't hear, if you can't see the audio, the video of it, don't worry about it, because it's just an angry person fighting with the lawyers on the other side of the table. And may your witnesses never do this. So I'll play this for you, and then we'll have a few exercises centering around from this video.
Did you talk to this man sitting next to you before this deposition started?
Yesterday, but he had nothing to do
I didn't ask you that.
Did you I said it though, didn't I?
Did you talk to him, sir? What did you say?
I said nothing. I said you have a case of incipient verbal diarrhea.
Oh, sir, we're going to see about that.
Well, good.
Did you talk to him yesterday?
Yes.
How long?
About 3 hours.
Mm-hmm. Talk about this case?
Yes.
Did you tell him the other companies you consulted for?
No.
So I'll pause here. This witness had refused to answer some questions like, who are your other clients and who else do you consult for? He had a privilege objection to it because perhaps he wasn't a testifying expert in those cases. He had a valid legal objection, but instead he wanted to be cute. He wanted to argue with a questioning lawyer, and it gets worse from here.
You're under oath here.
I did not.
We'll see about it. When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
research chemist.
And was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City.
Wait a minute, let me ask a question here.
Yeah.
Do you represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know, do you represent the guy or not? I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Why don't you keep your mouth shut and I'll do what I want.
No, you're not
Oh,
going to do
there.
what you want.
Oh, wait.
I'll do what I want.
No, you're not.
No, you're not.
Yeah, I am.
That's
I'm gonna make
bullshit.
whatever objections I want to make, and I'll make them as loud as I want to make them. Now, you need to shut your mouth and we'll keep the record straight.
Don't tell me to shut my mouth, boy.
Did you talk to Miss?
It devolves from there. It gets there's an invitation to go to the parking lot and fight. There's an invitation to and further devolution and unprofessional communication. My wish for you is that you never have a deposition like this. This was one that ended up in front of a judge. There were sanctions motions. There was crazy litigation and people making up objections on the fly, and it felt like an exercise in ego, not an exercise in trying to find evidence. And so what I'm going to do is I'm going to share with you a few ideas about objections. And there's a little bit of competing thought process, you guys. The Middle District of Florida, the federal court says all you should do in that situation is object to the form. There are other courts, not in Florida, but in other jurisdictions that say an objection to form may not be enough in some situations, because some situations you may have to give the lawyer a chance to cure a bad question through enough notice as to why you think the question is legally insufficient. But you have to avoid doing that in such a way that you'd be accused of making speaking objections or coaching a witness or making problematic objections. And so what we're going to try to do today is I'm going to move on from the video and the name calling, and I'm going to go to my PowerPoint presentation. And I'm going to walk through a few examples of objections that work and objections that could end up getting you in a little bit of trouble. All right. So the basics on objections is they should be short, they should be non-argumentative, and they should be non-suggestive. This comes from Rule 1.310. A version of those facts are stated in Rule 30 of the federal rule. There's a guideline for professional conduct that I'm going to talk about in just a second from the Florida Bar that you should be familiar with. And then there's the Middle District's Discovery Handbook. And again, the federal rule, Rule 30, and the Middle District are federal cases. I know most of your stuff does not take you to that space, but it's still illustrative and instructive for you as practitioners. But here's what the subsection 6 under depositions talks about in the Florida Bar Guidelines for Professional Conduct. It says that counsel should refrain from repetitive or argumentative questions that are asked solely for harassment. And then it goes on to talk about a level of courteousness. And then when defending a deposition, a lawyer should limit objections to those that are well-founded and permitted by the Florida or federal rules or applicable case law. And that counsel should remember that most objections are generally preserved and need only be interposed when the form of the question is defective or when a privileged information is sought. So that's kind of the general rule under subsection 6 and 7 of the Florida Bar Standards on Professionalism. And those standards on professionalism are adopted in virtually every judicial circuit throughout the state of Florida. So if you've got a lawyer who's behaving in such a fashion, your best weapon is not it might be the general language inside of 1.310, but it's the more specific language in Section F, subsection 7 of the Rules of Professional Conduct from the Florida Bar. All right, so let's talk about what's less versus what's more and form objections. The Middle District, in my general practice, is largely to say objection, form, and I stop. I almost always, that is my choice and my strategy. However, there are some courts outside of Florida. I have some cases from Iowa and Georgia, Alabama and Maryland that suggest that lawyers in some situations with unspecified form objections might have to do more to alert the questioner of what the defect is. In other words, if the questioner could have fixed the problem with enough notice by asking, for example, a non-leading question, then some courts, especially the Abbott Labs Court from Iowa, felt like the lawyer should have objected with enough specificity, brief, to put the lawyer on notice and give him a chance to cure the question. What I will share with you is that some judges might have a problem with that, depending upon the categories of objections. But if your objection is one that says objection leading, if the lawyer says, well, you're coaching the witness. No, I'm not. I'm coaching you so you can cure your question so that later on, if this witness testimony isn't admitted because of the leading question, I can argue to the judge that you had a chance to cure it. The Henderson case is a Nevada case, or excuse me, is a Georgia case. And it took a similar stance as Abbott about objections just to the form. And the quote is from that opinion says, an objection to form can be meaningless on its own standing alone and is contrary to what's contemplated under the federal rules. And so it's a little bit of a tug of war. I've got the Middle District and the Florida rules telling me that they need to be brief and succinct and non-argumentative. But I have courts from Iowa and Georgia that are suggesting that they need to be specific enough so somebody can fix it. And what happened in the Henderson case is because they weren't specific objections, they ended up overruling every single form objection where he didn't elaborate further for the basis. But there's a real risk on elaborating further because you're going to invoke the ire of your opposing counsel and judges if your elaboration is one that doesn't look like clarification, but instead looks like you're arguing or coaching. And we're going to get into some of the closer calls. The Ross case that's mentioned there in Alabama, a court there overruled objections to testimony that were just in form without further clarification. And so I'll give you some examples where more in an objection is a good idea. And the Mayer case, the one that's from Maryland, there was an expert deposition, and the trial court and the appellate court affirmed it, ruled that just all the form objections stated during an expert witness's depo were waived because they were non-specific and didn't get a chance to cure. We don't have opinions like this in Florida, but I do believe that there are certain more specific objections beyond objection form that you ought to consider in certain situations, and we're going to talk about those next. All right, so here are some exemplar objections that I think are good standard objections that gives the lawyer a chance to fix it. Objection leading, he gets to then ask the non-leading question. Objection compound, he gets to break it apart into little pieces. Objection assumes facts not in evidence, or objection foundation is another example that we saw in our whiteboard exercise, or even objection asked and answered. Those are all ones that largely don't suggest the answer to the witness. They're about a problem with the question, the repetitive nature of the question, the fact that you don't have a foundation or you're assuming facts not in evidence, the fact that you're putting a lot of questions together in a compound fashion, or the fact that you're asking a leading question of a witness who's not hostile or not an adversary. And so, I like these objections because they aren't, a quiet whisper to a witness telling him how they're supposed to answer stuff. But instead, they're ways that the opposing counsel is being informed of the defect in his question. And then if he chooses to proceed in response to that inquiry or in response to your objection and not try to fix his question, then you might not run into the same buzzsaw that the folks did in the Abbott case or in the Mayer case, where their general objections just to form were found to be not specific enough because it didn't give notice for the chance to cure. All right, so let's talk about some other objections that are maybe a little more what I'll call borderline. Objection vague, objection ambiguous, objection calls for speculation. When I have an opposing counsel who does that, it would shock you how many times the lawyer says, objection calls for speculation, and the witness says, and I say, well, you can answer. And the witness says, I don't know. I would just be guessing if I answered that question. And I've got to unpack it. And because I usually, at that point in time, fire a warning shot across the bow to the lawyer where I say, you just need to object to form. I know I'm not his lawyer, and I just gave you 4 or 5 examples of why an objection to form may not be sufficient. But, when you say objection vague and objection ambiguous, and the next words out of the witness's mouth when they're answering the question is, I'm sorry, but the question doesn't make sense to me. Can you clarify it? It's almost like the lawyer is coaching the witness. These are borderline because there may be a vague question that doesn't have, let's say you ask a question with no time reference, no geographic reference, no party reference that's required for someone to answer the question. Vague or ambiguous might make sense, but it's really more about the context in which they're used. Let's go to the bad stuff. All right, cool. So here are some improper objections. And I'm not judging anybody. And whoever put on the whiteboard objection relevance, all relevance objections are preserved. You do not need to make an objection to relevance. And if somebody does, you should educate them on the law. I can give you the case citation, and you should let them know that all relevance objections are preserved. And I love being able to tell somebody that because it shuts them up. And it keeps things quiet. And it keeps them from talking about the fact that it's almost like a lawyer who objects to relevance is a lawyer who wants to hear themselves talk. And there's a case that exceptionally helpful on this front And it's called David versus City of Jacksonville. It's at 534 Southern 2nd, 784. And it's in my materials on page 14. But the premise of that case, that the David case, is that objecting to someone's questions on relevancy or competency is not necessary in the course of that particular deposition. And so, if somebody is doing that, it's a lot of times they may be grandstanding. Another problematic one is, I can't stand it, is when lawyers will say things to a witness. They're not even the questioning lawyer. And I'll ask the question and they'll say, if you know, and they'll pat their witness on the arm. And then guess what that witness almost always says? Oh, I don't know. I can't remember. And so that sort of coaching of, oh, if you know, is very, very problematic. The witness will know if he knows, and the witness can tell me if he doesn't know, and he doesn't need you prompting him on that particular front. The volume or the type of objections can also be problematic. When we were looking back at that subsection 7 inside of the rules of professionalism, the rule there says that counsel should keep things limited to those that are well-founded and permitted by Florida law, and that most objections are generally preserved and only need to be deposed when the form of the question is defective or when you're seeking privileged information. So too many objections, it can be exceptionally frustrating. Lawyers can do it to break up your rhythm. It can be a strategy of some lawyers. And I keep the record on, tell the lawyer that his conduct is objectionable. And if he continues to do so, you're going to get the judge on the phone or bring it to the attention of the court. Don't let the lawyer go off the record to have a discussion about the objections or the appropriateness of them. If you don't want to go off the record and the other lawyer does, the court reporter should be staying on the record and recording the colloquy you guys are having. If somebody instructs a witness not to answer and it's not based upon a foundation of privilege, that's a problem. And you should also certify that question or bring it up to the judge if it's reaching an objectionable behavior. If you're instructing the witness not to answer because of something other than privilege, they are in very, very shark-infested waters. You shouldn't be doing it yourself. And I have a hack, and I'm going to share it with 100 of my closest friends on this Zoom. Sometimes I have a problem with a question, and sometimes it's going to require some involvement by the judge. And I need to get the judge involved with the question, but I will ask my witness not to answer the question. But what I say right after that is I'm moving or a tennis, so it's an oral motion for a motion for protective order regarding this line of questioning and this inquiry. And I'm not instructing my witness not to answer. I'm instructing my witness to not answer right now until we can get some guidance and clarification from the court. Now that sounds like a lot of word salad, and that's my specialty. Thankfully, I get paid by the word. However, let me just share with you that I think that is a good faith technique that you guys can use when you've got a concern over a legal threshold that hasn't been established and you think you need some judicial guidance. Rather than sending your witness out into uncharted territory, I make that oral motion for protective order. I offer to get the judge on the line. And then the other piece or part that is if I can't get it on the line and I offer up that we can have, after we can have a hearing on this issue, we can have a limited follow-up deposition on these particular issues. It's a whole lot better than, and then when the judge says, Mr. Adams, opposing counsel is telling me you instructed your witness not to answer, you can explain, Your Honor, what we were doing here is seeking some legal guidance on something. I wasn't instructing the witness not to answer, but we needed this legal guidance before the witness could answer. And it works relatively well, and it's a pretty effective strategy when you do need that guidance. But have a good record to do it, and offer up what I would call excess professionalism so that you can kind of take the storm away. And more often than not, what happens is opposing counsel frequently, if we can't reach the judge, they will move on and then not follow up and not call it up for hearing. They almost always drop the ball. Some people will follow through with it, but if you feel like you got a good basis for doing it and making the objection, then the hearing shouldn't be that uncomfortable for you. All right, so the last piece is a speaking objection. And there's so many examples of speaking objections. There's a third DCA opinion that's in my materials that has a list of what your speaking objections are. It's called Owens Corning versus Crane, and it's at 683 Southern 2nd, 552. Speaking objection is anything that's unnecessary commentary that suggests or influences an answer or non-answer, and they're just not allowed. So as much as I talk about my strategy and how sometimes objecting with a little bit more may be necessary to fix the question, if I've got somebody making speaking objections, I'll bring it up on the record. I'll tell them the speaking objections aren't appropriate. I'll cite the professionalism standard or the Florida rule, and I may bring up a case, and I'll let them know that their objections to form preserves their objection. If I want any more clarification from them, I will prompt them. The last piece I do is this, is if somebody objects to the form and I want to find out if I need to cure the question, I rarely do it. But if something in the back of your head, because I don't want it to turn into where the lawyer gets the disruption. But if I'm worried about a question I asked and the nature of the objection, I can ask the lawyer, what's the basis? And the lawyer may say compound question, worth pleading. Or sometimes, I love this makes me so happy. Sometimes there's this uncomfortable silence because the lawyer's trying to figure out what his objection is because he just said objection and he didn't know. I love those moments. You know, the uncomfortable silence that our manager, Glenn Sturgis, filled with uncomfortable ramble. I love them when the other side is sitting there trying to rack their brain and think what their basis was for an objection. You know, and it's almost like, well, something's got to be objectionable here, you know, and so it makes me happy, you know, when you can correct somebody's conduct, you know, with a well-placed response to excessive objections. It doesn't have to be a skirmish. Don't be afraid of getting the court involved if you need to. And more often than not, if you give somebody, you know, the chapter and the verse and let them know their speaking objections aren't appropriate, and if you need something more than objection to the form, you'll ask them. It can really, really change the mood and the tone of a deposition. And I know you guys as a team deal with so much confrontation, so much conflict, and it's often escalated emotionally and highly personal, and the stake and well-being of a child is at issue. And so this is really, really high stakes litigation. And I have found that in high stakes litigation, it can more often than not make someone's conduct or behavior head scratching, you know, because it's like sometimes lawyers for the win can grasp at straws. And so, you know, judges with the sort of litigation that you have, they get annoyed with discovery skirmishes and hearings. But if you're the one who's brushing somebody's ears back and you follow the case law, the judge shouldn't be frustrated with you. So don't be afraid to seek judicial involvement. So let's pause. I'm so proud of you guys. You've survived 2 of my subjects. The next subject we're going to talk about is ethical witness prep. And then the subject after that is fun in the pandemic and dealing with pandemic issues. But I have a news story I want to commend to you guys. And this is not intended to be a political comment, but I saw in front of Congress yesterday or the day before yesterday, some of the worst examples of witness coaching on a hot mic that I've ever seen in my entire life. And it's really short and it's very newsworthy because it's popping up on all the news cycles. This is not meant to be brought up for anything other than the example that it is. It's not meant to be political. But Wexler, who's the chair, or at one point in time was the chair of the Limited, and Victoria's Secrets, was deposed in front of Congress. And his lawyer, if you haven't seen this news story, he was rambling on about all sorts of stuff that's in the news and all sorts of relationships with people that he's got that are newsworthy. And his lawyer leans over and whispers in his ear, and it gets picked up on a hot mic because video depositions, everybody's got a mic on. And he says to him, with profanity, and I will omit the profanity, if you answer with more than 5 words to any questions going from here forward, I'm going to kill you. And this is his lawyer talking to this guy because he was rambling on. And it got picked up on a hot mic. You should always presume that there is a hot mic. So on ethical witness preparation, I'm just letting you know that the best thing that you can do is don't do your preparation during the depo. That's unethical. The whispering piece. You should do your prep on the front end. We've got about a half an hour left. And these next 2 subjects will go relatively quickly, but we're going to go through some hypotheticals. And so I'm going to put up on the screen, and I want you to, we were going to do a poll, but we've had some technical difficulties. So I'm going to put up on the screen 4 hypothetical questions. I'm going to read through them, and then I want you to put your answers in the chat. So that's what we're going to be doing now when we talk about ethical witness prep. So we were going to use a Zoom poll, but instead we're just going to use the chat, and I'm going to give it a few questions. So take a look at the first question. We got hypothetical. It's called scripted memory. You're preparing a fact witness who's nervous and tends to ramble. To help them stay focused, you draft a short outline of key points that you believe they should emphasize. And during the prep, the witness begins reading your outline verbatim and asks whether or not they should just memorize it so they don't mess anything up. So you have 4 options here. A is tell the witness that memorizing the outline is okay, as long as they stick to the themes. B is encourage the witness to memorize the outline because it'll be consistent. C is you can tell the witness, use the outline to understand stuff, but your testimony has to be in your own words and based on your own recollection. And then D is tell the witness to ignore the outline entirely and refuse to discuss any topics that might come up. D is absurd, so I'll go ahead and give you the hint. D is not your answer. All right, so what are we looking at here? The right answer is C. You can give an outline to a witness if you want to, but be aware that if that witness is not your client, that may not be privileged. And any outline you give them may be discoverable. They may say, what did you do to prepare for your testimony? Did you receive any documents? Did you receive any outlines? So unless you're prepared for your work product to have some sunshine on it, this outline idea may not always be a good idea unless you've got privilege. But to the extent that the witness is telling you, hey, I'll just memorize this stuff, and you can tell them your testimony has to be your own testimony, and it has to be based on your actual recollection. So C is the right answer here. We're going to go to our second hypothetical in the interest of time. The second hypothetical, and I'd love to see your answers in the chat. The second hypothetical is the helpful timeline. There was a multi-month series of events, and the witness has really bad memory. We create a timeline based on documents, and you ask the witness to review it, and the witness says, I don't remember any of this stuff. But if you say it happened and the documents say it happened, man, I'll just testify to it. And not unlike the helpful, the helpful script, the answer is the same on this one. It's C. You can explain to the witness that they can use their timeline to refresh their recollection, but you can't make the timeline your factual testimony if they don't personally remember it. And unless the witness says, I don't have any recollection, but but adopts the timeline. But be careful, because again, this timeline, if work product or if privileged that's been created, it says you, the lawyer, created the timeline. If they review it and rely upon it for their testimony, you could be taking something that's work product or privileged and turning it into something that's discoverable. I'm going to move on to hypothetical 3. Hypothetical 3 is about a missing document. We've got a corporate employee who's going to be deposed. I know you guys don't see a ton of corporate employees in the course of your representations, but during this prep, for this hypothetical, it'll teach us the right thing. During the prep, the witness says they don't remember reviewing a particular internal email, but you know the email was sent to them, but you don't have any evidence that they actually read it. And the witness says, should I just say I never saw it? And rather than going through the exercise, the right answer here ethically is B. You can tell the witness to say they don't recall reading it unless they're certain they did. The other answers are too fringe. They're a recipient to the email, and saying that they didn't receive it or never saw it is a little problematic, because the line of questioning afterwards is like, well, don't you read your emails? And weren't you working here on this particular date? And this is your email address, isn't it? But in reality, we know that just because something lands in somebody's email inbox doesn't mean they've read it, doesn't mean that they've digested it. And for a witness to say otherwise, might be suborning some sort of testimony that is less than accurate or less than truthful. And so, in my opinion, B is your best answer on this one. So our last hypothetical that we're going to go through is the remote whisper. And this is exactly what happens in front of Congress with Wexler yesterday. The witness struggles with dates, or perhaps in this situation, the witness doesn't know when to shut up. The witness looks confused and pauses. And in this situation, the lawyer was on Zoom and muted the Zoom and whispered the correct date to the person. The lawyer in this hypothetical was trying to be helpful, because let's say everybody in the room knows the date except the witness. Yeah, that happens sometimes, where folks will be like, everybody in the world knows the date, but the witness can't recollect it. And you think you're just trying to be helpful, but the deposition is about the witness's recollection. And so this sort of whisper shouldn't surprise you that it is B. It's improper, because any off-camera or muted coaching during testimony undermines the integrity of the deposition. And I would submit to you that even if it's not muted and it's whispered into someone's ear and can be overheard on a hot mic, that wasn't intended to be overheard. What happened in front of Congress the other day, it's inappropriate. It's the witness who's there. And so that's why the prep you do on the front end is so very important. So I'm going to get off of my hypotheticals now, and I'm going to move to talking a little bit about the ethics of prepping your witnesses, and talking a little bit more on some of the issues that our hypotheticals touched upon. Remote technology presents all kinds of problems. You've got chat, you've got somebody who can other devices like a phone or an iPad. You've got all sorts of unique ways that can happen, because you don't even know where my cell phone is right now. My cell phone is right here. And the whole time I've been talking to you, I could have been receiving texts and factual information if I was testifying. And so I go through a script at the outset. Are you by yourself in the room? Do you have any electronic devices with you? I want your undivided attention. Is it fair if somebody might say, well, I have to leave my phone on because my babysitter may call me. I get it. Can you do me a favor? Can you put your phone face down on your desk so that it won't distract you during this, but leave the ringer on in case your babysitter calls you? Come up with some protocol, because remote technology invites cheating. And unethical preparation can be sanctionable. In 2021, the Florida bar disciplined a lawyer for texting a testifying witness during a deposition. In Arizona, the next year in 2022, an Arizona lawyer used the chat feature of a remote platform like Zoom and instructed his client during cross-examination. Those are no-nos. You can do your prep. You can do your prep on breaks. You can't wink. You can't gesture. You can't pass notes. You can't kick under the table, and you can't do electronically what other people weren't allowed to do when you're inside the same room. All right. So here are some precautions. I like to time my breaks, whether it's and I like to have this as a standard rule across the board. I even tell my witnesses this when they're being deposed: is if there's a question pending, we're not going to take a break. We're going to answer the question and then we'll take a break. The reason being is that if during a break there's a question that's pending, it is susceptible of coaching. And I think when there's a pending question, if you talk to your client about that pending question, you've got problems, and it may not be a privileged conversation. And so I love the idea of we take a break. There's no pending questions. I can have a privileged conversation with my client as long as I'm not breaking the rules of ethics and telling them to testify untruthfully. I think the other thing that helps diffuse unethical witness preparation is skillful cross-examination. Have a script ready for yourself of saying, we just took a break 3 minutes ago. And before the break, your testimony in response to this question was X. And after the break, when you met with your lawyer and you guys took this break, your answer went from X to Y. And what did you look at? What documents did you see? What led to the change of your opinion? I pray for a privilege objection there. Privilege, my client, I'm going to instruct my client not to answer because it would reveal the attorney-client communication. By the objection, the lawyer has just told me that he talked to his client. And if a judge or a jury hears it, they're gonna put a lot less stock in the changed answer. So a good, skillful cross-examination script. I don't do this often, but sometimes, and in some jurisdictions, they have court orders and protocols for remote depositions. Either protocols agreed to amongst counsel or court orders that might be standing or administrative court orders. I think with our rules of professionalism and with the administrative orders that adopt the rules of professionalism that we've got, and with a new ABA model standard or formal opinion, it's called 508, and we'll talk about that in a second. You may not necessarily need that protocol formally. I find that when judges have been asked about it in the past, they've been reluctant to do it because they think the rules of professionalism are enough. But if you start experiencing problems with it, you can ask the court for some sort of standing court order or court order going forward. I want to talk a little bit about the sanctions piece. The sanctions piece, it can be ugly. It can involve suspension. And it can involve, real problems in the case. It can involve the lawyer getting disqualified from the case. I've not seen a disbarment piece, but I have seen significant suspensions as a result of this. And I think that, and I'm going to turn to 508 next. There's this ABA formal opinion, and it's called Formal Opinion 508. And the gist of it is entitled The Ethics of Witness Preparation. It is very short. It's only 11 pages long. It is readily available and accessible. And it's a very, very good white paper, and I would recommend it to you. It gives you an example of problematic conduct. It gives you the sort of preparation conduct that is ethical with bullet points, and then it gives you a narrative and case citations to the sort of conduct that's not ethical. And it's a great coaching piece. It's a very manageable read, and it's also a great piece to weaponize against your opposing counsel. And so I would encourage the read, and it starts on page 3 of the opinion and only goes to page 4 of not the formal opinion, but things like reminding a witness that they're going to be under oath, suggesting proper attire, context for the witness's testimony, identify other testimony that might be presented or explore their version and how it compares, providing context, explaining that telling the truth might sometimes involve saying you don't remember. All those things are great. They're all the acceptable behaviors. It's the other unethical stuff, like encouraging somebody to give false testimony. Oh, Glenn's competent. He's a great manager. That's false testimony. You violate your ethical obligations if you assist somebody in offering false testimony. And so in my opinion, our goal isn't to do anything other than help the witness do the best job they can in telling the truth and providing actual testimony. We can't provide unlawful inducements. All right, if you can answer every question in less than 5 words going forward, I'll buy you a Starbucks gift card for $50. We can't do those sorts of gamifications or inducements. you can't do that to not testify either. There's some ethics behind that too. And there's a really good example of unethical conduct during witness testimony and some examples of remote settings. And it gives some really good practical examples on pages 9 and 10 of protocols that you could use, some of which I've talked about here. Sometimes it could be a motion to terminate the deposition and for sanctions. It could be for the protocol piece. It could also be that in this case, you would only do in-person depositions. I've seen some judges order that when there's been abusive practice. But 508 is a treasure trove. And whether it's the old school stuff like kicking under the table or the new school stuff like chatting or chat functionality or messaging, either way, we need to let our witnesses tell their stories. And if you are experiencing abusive behavior, 508 and that from the ABA has a great treasure trove. Cool. So we are down to our last topic and our final exercise. Our last topic is on the issue of navigating post-pandemic hurdles. And the post-pandemic hurdles we're talking about here are things like, Zoom connectivity, the internet, and the pain that is. Now, here's the part where you should not be adjusting your monitors or your computers. The next two videos are short but humorous videos about stuff that can and often does go wrong during Zoom conferences. The first is called Every Zoom Call, and it's stereotypically. And the other is What If Zoom Calls Were Like Real Life? The first is done by a group very popular from the internet called Dude Perfect, and they're wonderful. And the second, they're funny, and my kid likes to watch them on YouTube. The second one is done by a Christian comedy troupe that often will present, work type scenarios at seminars and stuff like that. So I'm going to go to the first video, but while you're watching the videos, I want you inside of the chat to identify certain complications you've had with remote technology, whether it be meetings or hearings or depots, whether it's camera stuff, whether it's chat stuff, whether it's audio stuff or video stuff. I want to hear your pain. So while you're experiencing the pain that these folks have in a funny way, and while you're having a few laughs, it would make me really happy if you would share with me in the chat, some of the pain you've actually experienced and some of the difficulties you have. I think it would make a great place in our word cloud. So let's go to our first video. Our first video is the short 1-minute video from the folks at Dude Perfect. So here this one comes.
All right, we got everybody. Thanks for hopping on, guys. We'll try and keep this quick. Update us on last week, how that went.
As far as an update with news, everything was travel. Which is the bad.
You're cutting out a little bit, and we've lost him. Okay? Oh, Dave, are you frozen?
I got you. Oh, I did.
Okay, I thought I mentioned last week the jokes aren't playing as well on here. So, Rick, we know you're not in space. Guys, please. Jim, what do you got for us? You're on mute, Jim.
Can you hear me now?
What's in the background? You've got a lot of...
You won?
Go back on mute. We'll get an update later.
Yeah, I'm going to go on mute.
Man, I wish I could zoom away from my boss right now, am I right?
Jim, you're not on mute now.
What?
Okay? On a side note, I would just like to point out how attentive that Robert has been this whole meeting. I appreciate that. And that's the kind of thing that is going to get you guys raises at the end of the year.
Yeah, I'm shocked if I'm ever up by noon.
All right, so that's Dude Perfect and a 60-second vignette of all the things that can go wrong during a Zoom call or how to cheat your Zoom with your cell phone with a video of you thoughtfully nodding. This next one is another example of the difficulties that you can experience in remote technology.
All right, we got everybody?
Let's see here. Here's our next one.
Hey, Paul. Thanks for being here on time. Paul? Hey, Paul, can you hear me? I can't hear you. I can hear you. Can you hear me?
Hey, guys.
Hey, Tyler.
Sorry I'm late. Having a hard time connecting.
1 second. Paul's having a sound issue.
I can't hear you. Try adjusting your output settings.
Can you hear me?
It's the gear icon.
Tyler, are you on hotel Wi-Fi?
Yeah, why?
Never mind, I got it. I just had to change a few settings.
Maybe we can get started then. Oh, great.
I think your mic is picking up your speakers.
My mic?
Do you have headphones?
You want me to put them on?
No, I want you to smell them. No, I want you to put them on. Hey, Beth.
Hey, everyone. Sorry I'm late. I had to download a new version of the platform.
You should plan extra time for the updates. There's pretty much one every time.
Sounds like someone just joined.
Hey guys, it's Joe. I had to call in. I'm stuck in traffic. Have I missed anything yet?
No, it would have been nice for you to join the rest of us, but we'll see you when you get home. All right, while everyone is here, finally, Tyler, do you have that financial report?
Well, it's been the last few weeks updating our books, and I got some great news for you. Schedule from this point last year. We had a great Q1.
We lost Tyler, I think.
Am I frozen?
Hey, Trip, I think we lost Tyler.
Yeah, I know. I know we lost Tyler.
Hey guys, it sounded like Tyler was cutting out.
We know, John. All right, while we wait on Tyler, why don't we go over all of the reports from... Beth, are you with us?
Oh, yeah.
Okay, everyone, I know some of you have to leave soon, but I just wanted to go over a couple of the queries before. Okay, excuse me. My wife's out of town this week. Daddy's... I'm so sorry. Okay, you just spilt grape juice on the carpet. Daddy is in a meeting. Tyler, can you go over the numbers one more time, please?
I thought Beth had an adjustment. Hey, Beth.
Yeah.
Sorry, guys, that's my iTunes.
Hey guys, hang on. I'm gonna join in. Hey, what platform are you guys on? Skype? FaceTime?
It's in the invite.
Oh, never mind. I see it. It's right there in the invite.
Okay, now I can see everybody.
Let's reschedule and let's just do a regular old conference call, okay? Paul, can you have David send out the 9-digit passcode?
I heard you.
Yeah, he's been here the whole time.
All right, everybody. I'll see you later.
So I paused the video. I edited this video, but I paused the video because at the end of the video, the person who was at the head of the table stands up and he's only wearing professional clothes from the top up and he's wearing tidy whities from the bottom down. And so I saved you guys from that. But the things you will see on a Zoom call, these are stereotypes. And you're going to see some of that. And I have over 99 messages inside of the chat that are sharing some of the fun things that you guys have seen. I'm going to turn back on my PowerPoint presentation so we can talk a little bit about some strategies on what you can do when you're dealing with remote technology fun and difficulties. So let me go back to that real quickly. All right. So we talked about remote technology issues. I will tell you that as much as I love the ABA 508, the only thing I like more than that is there's an ABA resolution that's called 505. And it's also widely available. And you know what it's all about? Best practices for remote depositions. And it was written about 3 years into the pandemic. And it's wonderful. And so I would commend it to you. But some of those best practices is know your rules, the local rules that govern your depositions and online depositions. Test your technology. Guess what we did today and yesterday? And we still had technology problems. We tested the audio and the video of this very CLE presentation. And still some people on remote technology are still having some difficulties with it. It's life. There's going to be gremlins and you should test it. You should prepare for a remote deposition like it's a remote deposition. They can be more complicated. Sometimes the exhibits require a little bit more planning. And that brings me to managing my exhibits. Stuff that has tiny font, stuff that's difficult to read, stuff that is difficult to open, stuff that's really voluminous and you don't know what page a witness should or shouldn't go to can create real problems with an electronic deposition or a remote deposition. So having things teed up, having them bookmarked, having them ready, having them in a font size which is legible where it's zoomed in. And then, not that I'm pessimistic, but anticipate problems. You're going to have some problems, and some of them might look just like those videos that made us laugh. Well, the reason they made us laugh is because they're so stinking true. And you should anticipate some of the potential problems that you're going to end up having. The one thing I want to talk to you about is there's some case law suggestions that I'd like to talk to you guys a little bit about. And one of them is a federal rules decision from Illinois, and it's in my materials, and it's from Chicago. And in that case is called Alcorn. And an attorney used a Zoom's built-in recording feature rather than hiring a certified videographer to record the remote deposition. And that's a problem. You can't make your own video deposition through Zoom recording. The court reporter may choose to record it, but you can't do that. Another one, Newsom is the name of the case. It was a case also from Illinois. And it was a case where somebody decided that they wanted to record a remote deposition on a cell phone without following the right notice requirement. That's a knowing the rules situation. This happened to me not too long ago. I went to South Dakota and I came back and survived, but I went to South Dakota and I was defending a witness's deposition and the lawyer's getting all set up. And he's got his laptop and he's got a webcam and he's turning his external webcam around and facing the witness and acting like his own videographer. And, we had quite a skirmish. And I said the deposition wasn't going forward. It wasn't properly noticed. And that, I really worry about a lawyer he says, well, I'm not going to use it as the official record or transcript. I just want to have it so that I can go back and review what transpired during the deposition. And court reporters have real problems with that because it's like an end around trying to get a copy of the transcript without paying for it. And so the Newsom and Alcorn opinions did not exist at the time that I was having this skirmish up in South Dakota. I wish they had, but it ended the right way because the lawyer took it down and ended up taking his webcam down. All right. So we're going to talk a little bit about a closing exercise next because I will tell you that there's some other things inside of this subject matter that I'm going to go back to really quickly. There was things like exhibit management. We've talked a little bit about the exhibit management piece. having them bookmarked and identified, either highlighted or right font size. We've talked a little bit about sometimes handling uncooperative witnesses, either through the examination techniques and the funnel and meaningful cross-examination. But I want to talk about those two issues first for just a second, and then I want to go to our closing exercise. On the exhibit management front, when you're doing digital prep, consider having high contrast information. In other words, have stuff where it's easy for somebody to read on a computer screen, where it's optimized for the computer screen. Another helpful tip is consider the court reporters you're using. They may provide a dedicated platform for exhibit sharing. I use US Legal largely. US Legal has a proprietary platform where you can upload stuff into their exhibit portal, and you can either choose to share it with everybody all at once and tell them pull up exhibit 1 or pull up exhibit 2, or you can let line out a little bit at a time. And you say, okay, I've just forwarded you exhibit 1. It will go to the lawyers, it will go to the witness, and you can just focus. I love that because it keeps me from being distracted. Sometimes court reporters I'm working with don't have that, and I'm forced to email to a group or place an exhibit into the chat. I like having all of my exhibits in a folder on my desktop so that I know where they are and they're easy to find, and that they're kind of trimmed and easy to read. On an uncooperative witness, the key there is the same key with any witness, and it's extensive preparation. Set and ground rules, position yourself and your body language in such a way where it's an authoritative. And I have found that if you have an uncooperative or hostile witness, if you escalate like the guys in Texas did, all it does is lead to escalation. I believe that escalation breeds escalation. If you instead speak from a position of calm authority with professional admonitions, you're going to get a better result. If instead, there's a saying about, don't wrestle with a pig in the mud, because you're both going to end up covered in mud and only the pig's going to be happy. If you've got an uncooperative witness who's being unprofessional and combative, the answer to it is not to be equally combative. The answer to it, in my opinion, is to be professional, authoritative, and calm. Because you're not taking the bait. Your behavior is above reproach. And somebody who's behaving in a bully or in such a fashion frequently will back down into the face of professional admonitions. And if they're being uncooperative, the threat of getting a judge involved if necessary can often, wake certain situations up. So those are some of the tips on exhibit management and uncooperative witnesses. And I want to go to our closing exercise. I kind of was referring to this one as the whole burrito. And the reason why I'm calling it the whole burrito is you had all this instruction on the issues that we're talking about here. Issues related to gathering information, issues related to dealing with objections, issues related to the ethics of witness preparation, and issues related to post-pandemic hurdles. And I'm going to ask you to watch this next video. And this next video is the one that was about the Cuyahoga County up in Cleveland. They had a public records case. And there was a fight about what a photocopier was. And that language appeared inside of a statute. And they had some wrangling with this employee about whether or not there was a photocopier in the county recorder's office. The whole case was about whether or not deeds and other records should be readily available to be copied by somebody at a reasonable cost. The exchange, it's a 10-page transcript that's in this video. And it was reenacted by actors. And the witness is a guy named Lawrence Patterson. And he's the head of information technology for the county's fiscal office. And the questioner, with increasing frustration, is a guy named David Marburger. He's an attorney who filed the lawsuit on behalf of some title companies who wanted to be able to access these deeds at a reasonable cost. And the other attorney is a guy named Matt Kavanaugh, who represents the county. And so what I want you to do, as suggested on the slide here, is I want you to identify issues, whether it's prior discussions and coaching the witness to not be cooperative and play games, the problems that are there, some strategies that you might use in the face of this situation, some solutions, ethical issues, those sorts of things. I want you to pepper me in the chat with all those sorts of things for our word cloud, because you're going to see stuff inside of here with an evasive witness who is clearly prepped to play word games with the lawyer. And in this situation, I want to commend the lawyer because David Marburger, the questioner, did not invite anyone to go out into the parking lot. You can tell he's increasingly frustrated, but he did not invite anyone to go out into the parking lot. So we now find ourselves at 125, and I'm going to start the video, and I look forward to you showing me everything that you've learned inside of the chat regarding strategies, solutions, and issues that we've talked about today. So without further ado, here comes your final exam.
And the device used to record information from your computer system onto the master CD is a device within the recorder's office? Is that correct, as opposed to being in some other building somewhere?
Yes.
During your tenure in the computer department at the recorder's office, has the recorder's office had photocopying machines?
Objection.
Any photocopying machine?
When you say photocopying machine, what do you mean?
Let me make sure I understand your question. You don't have an understanding of what a photocopying machine is?
No, I want to make sure that I answer your question correctly.
Dave, I'll object to the tone of the question. You make it sound like it's unbelievable to you that he wouldn't know what the definition of a photocopy machine is.
I didn't ask him to define it. I asked him if he had it.
When you say photocopying machine, what do you mean?
Let me be clear. The term photocopying machine is so ambiguous that you can't picture in your mind what a photocopying machine is in an office setting?
I just want to make sure I answer your question correctly.
Well, we'll find out. If you can say yes or no, I can do follow-ups. But it seems, if you really don't know in an office setting what a photocopying machine is, I'd like the Ohio Supreme Court to hear you say so.
Sorry about that.
I just want to make sure I answer your question correctly.
There's different types of photocopiers, Dave.
You're speaking instead of... You're not under oath. This guy is.
I understand that, but I understand what his objection is. You want him to answer the question. I don't think it's fair.
It's not fair?
It's not a fair question. A photocopy machine can be a machine that uses photostatic technology, that uses xerographic technology, that uses scanning technology.
I don't care what kind of technology it uses. Has your offices... We don't have technocrats on the Ohio Supreme Court. We've got people like me, general guys
Objection.
Or gals. I'm not really very interested in what the technology element of it is. I want to know.
That's what's at issue in the case, Dave.
Not in my judgment. Do you have photocopying machines at the recorder's office? If you don't know what that means in an office setting, please tell the court you don't know what that means in an office setting to have a photocopying machine.
I would like to answer your question to the best of my ability.
I'm asking you to answer that.
So if you could explain to me what you mean by...
I'm not going to do that, because I want to establish on the record that you really don't know what it is. I want to establish that. Now, do you know what it is, or do you not know what it is? Do you understand what that term means in common parlance or not?
I'm going to pause it here in the interest of time, because we have 2 minutes left, and I'm going to cut to the final scene, where this witness has the chutzpah to say, oh, I just used the word Xerox, and that's how the inquiry goes. So I'll give you the last 30 seconds. But my favorite character in this whole thing is the court reporter. Look at her expression. It is magical when you look at the court reporter's expression. She's been doing this for years, and she can't believe what she's hearing. So here's the last 30 seconds. Well, let me rewind. Hold on.
I'm sure it's been used. I don't remember a specific instance or how it was used. I'm sure it's been used.
And is it fair to say that it's been used in terms of being able to copy one piece of paper onto another piece of paper using a machine? No? Not sure of that?
I'm sure it's been used. I don't recall a specific instance in which it was.
Do you have a secretary?
No.
Does anybody there have a secretary?
Yes.
Have you ever heard a secretary use the term photocopy?
No.
Have you ever? Do you have machines there where I can put in a paper document, push a button or two, and out will come copies of that paper document also on paper? Do you have such a machine?
Yes, sir.
What do you call that machine?
Xerox.
And scene. 10 minutes and 10 pages of a transcript, and they were fighting over a photocopier and Xerox. And if any of you guys think that skirmish wasn't engineered and or coached by the lawyer, kind of encouraging that witness to be less than forward, and I love Jennifer's observation. This is a great instruction, which is how in the world is that court reporter able to have such demonstrative expressions on her face while everybody was also talking out loud at each other? The yelling part of it all, this was a textbook example of gamesmanship in the witness preparation for the witness to be less than forthcoming, and all over a fight. And then I love it so much because at the very end he just says, "Oh, you were talking about photocopiers. We use the term Xerox." This was an example of a witness being encouraged to be obstructionist. And I don't know if it rose to the level of unethical, because nobody's asked me to call that ball or strike, but it rose to the level of absurdity, to the point where this transcript got circulated and the Upright Citizens Brigade decided that they wanted to make a video about it. I think that whether it's from Tim, from Jennifer, and from others in this group, you guys have a ton of experience out there. And if you're experiencing depositions like this, there were things that lawyer from Ohio did that I think escalated it a bit. His exasperation, his frustration. And the other lawyer, he was making speaking objections, and he clearly had coached this witness. At the end of the day, I think that the lawyer did a pretty good job, aside from raising his voice and yelling and screaming, of making the witness look like he was being absurd. And that's that whole effective cross-examination piece.